So an interesting case there in the High Court at the moment. It's a dispute which shows the amount of money that's available for accommodation of international protection applicants, in other words, asylum seekers. The hotel owner in this case claims that he could lose 2.1 million euros from accommodating international protection applicants because the current operator of this person's hotel in Wicklow will not surrender vacant possession. The hotel in question is the Grand Hotel in Wicklow. The owner of the hotel has brought proceedings against an operator seeking orders that a lease agreement has ended. The owner of the hotel claims it could lose up to 2.1 million euros for accommodating international protection applicants because the current operator is refusing to give up and surrender vacant possessions. The company brought the proceedings against the company which currently operates the Grand Hotel in Marlton Road in Wicklow Town. Back in 2017, the owner of the hotel leased it to Vesta. That's the company that operates it at the moment. The hotel has 35 bedrooms and 2 conference rooms, along with a kitchen, nightclub and a car park. The owner of the hotel is seeking declarations and orders from the High Court that a lease agreement ended last August 19th and that Vesta, the current occupier, has been occupying the property as a trespasser since October the 1st. It's also looking for damages for losses suffered arising from the alleged trespass and breach of contract. The director of the hotel owner said in an affidavit that 2 years after entering into the lease, its terms were varied, under which it was noted that since December 2018, the hotel has been used by Vesta to provide services to the Department of Justice Reception and Integration Agency. The lease was extended then in August 2022 for a further 2 years. Mr. Tobin said that Vesta also signed a deed of renunciation, giving up any rights to a long-term lease. In the middle of 2023, MBE asked Vesta what it wished to do when the lease ended the following August. It's claimed that the Vesta director said that he had no interest in extending the lease. Last May then, MBE wrote to Vesta stating that the lease would expire in August and asking that the property be handed over, but there was no response per se from the occupier of the hotel. In the meantime, MBE was in contact with a firm who runs international protection accommodation services centres. It reached agreement in principle last June with this company, and the expected turnover or expected gross income for a 12-month period is 2.1 million. There's an agreement with the Department of Integration to enter into a contract for the hotel once Vesta, the existing occupier, gives up vacant possession. Mr. Tobin believes that the company that he's doing business with intends to operate a model similar to other IPAS centres in the Grand Hotel, with Townby ULC managing the day-to-day running of the centre. We're looking at what he's expecting is a profit-sharing arrangement whereby MBE receives 25% of the gross income under the contract. Mr. Tobin said that there are currently 300 people being accommodated at the hotel, and MBE would receive 2.1 million euros for 2024-2025. Even if the number of people was to fall to say 200, that would still mean that MBE would receive 1.4 million. He claimed that Vesta, the current occupier, has an incentive to drag out the proceedings for as long as possible while making considerable profits. Vesta then, its director, said that the firm currently operates a contract with the department on a monthly rolling basis. He said MBE appears to be proceeding on the assumption that the department would grant it a new contract to house refugees immediately. From the defendant's experience of dealing with the department, there's no reasonable prospect of that happening. He also said that MBE only has an agreement in principle to enter a lease with the third party, not a binding agreement. He also said that Vesta put about 1.7 million euros into the property since it took it over and is entitled to remove its items from the property if required to do so. The case has been entered on the fast-track commercial list. The defendant had agreed to mediation, but only after proceedings had issued. Senior counsel for Vesta, that's the current occupier, argued that the case did not meet the threshold for entry into the commercial list. However, the judge accepted the case. He welcomed that mediation is to take place and adjourned the case to later this month. So as you can see, there's a fair amount of money involved in the provision of accommodation for international protection asylum seekers.